Robertson. I call Andy Wightman to be followed by Stuart Stevenson, and Mr Stevenson is the last speaker in the open debate. Mr Wightman, please.
Thanks, Presiding Officer. I want to focus my remarks on the serious harm threshold because it's a significant change. It exists, of course, in England and Wales in Section 1(1), which states that a statement is not defamatory unless its publication has caused or is likely to cause serious harm to the reputation of the claimant. The bill before us, by stark contrast, does not follow that straightforward formulation, but instead defines a statement as defamatory if it causes harm, but then in addition states that for it to be actionable, that harm must be serious. And so in that respect, I disagree with Adam Tompkins that Scots law is being brought into line with England and Wales, and I'll return to that. Now, following the Supreme Court ruling in La Chaux, liability and defamation cannot be established by reference to the inherent tendency of the words alone, but has to have regard to the facts and the circumstances. And thus, the court will need to hear evidence on whether the alleged words written or spoken were indeed ever written or spoken, whether they bear the meaning alleged by the pursuer, and the reasons why, if defamatory, serious harm is or is likely to be caused. And that does require an evidential hearing. And thus there will need to be significant procedural rule changes to Scottish civil procedure to accommodate any pre-proof evidential hearing. I have 4 arguments against the serious harm test. First, as a matter of principle, we should not be shutting down civil law remedies for people without good reason. Someone, for example, who is defamed but only suffers harm is now to be denied redress, as is someone who suffers repeated harms over perhaps a long period of time, but where the threshold may never be met by any one instance. Secondly, as a caution to those who think this may act as some kind of procedural hurdle, as I said earlier, this will involve an evidential hearing and associated expense. In my recent £750,000 action, I would still have been in court for 6 days trying to thrash out whether in fact serious harm had ever been caused to the pursuer. Thirdly, a serious harm threshold will not deter a litigant determined to damage someone. That's what happened with me. It took a full proof, as I say, to conclude that no harm at all had been caused and no financial loss had accrued to the pursuer. And finally, fourthly, but very important, let us ponder what Parliament's being invited to do. Because Section 1(4)A states that a statement about a person is defamatory if it causes harm to the reputation, as I said earlier. And incidentally, this was not in the Scottish Law Commission Bill, and the Scottish Government has never published an analysis of responses it got to its own consultation. But any such statement is only actionable if the serious harm is serious. Presiding Officer, we're defining a civil wrong in statute, then saying there's nothing you can do about it. We're now seeking to deny civil justice to our constituents whose reputation has been harmed. Is this even compatible with Article 6 of ECHR? Presiding Officer, the threshold does little for defenders, as full proof will still be required. The threshold, on the other hand, does a lot for pursuers, but in a wholly negative way and without justification. The bill risks denying legitimate pursuers their human right to a civil remedy for a wrong that we are defining as harm, but about which they can do nothing unless they can prove it is serious. Why?